So what effect does it have if a creditor issues a 1099-C saying debt has been canceled? Does that make the debt go away? What impact does that have on your credit reporting? So welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And we're going to look at this case of Rhonda Jackson versus Truist Bank. Also Equifax and Experian were sued. This is from Kentucky, the Louisville Division of Western District. And this is what's called a motion to dismiss. So there are no depositions. It's merely looking at what does the lawsuit say? And then the question is that enough that the consumer can win? Not is it more likely than not the consumer wins, but is it more than just a mere possibility? So here are the facts. The husband files for bankruptcy, but the wife does not. The wife is the one who ends up filing the suit. And at some point, there's a 1099-C to both Rhonda, the plaintiff, and her husband, Donald, saying this debt had been discharged or canceled. Now, so it's not confusing, the husband did file bankruptcy, but that does not discharge the wife from her legal obligations to that debt. So the question in this case is, what effect does this have, the fact that the wife got the 1099-C? So Truist, which is the successor bank, it started off BB&T, and then it went to Truist. And let me get this, might make it a little easier to see. So Truist reported the debt to three credit reporting agencies, and she disputed it, saying, hey, you can't discharge it under 1099-C and still claim that I owe a balance. But that's what they ended up doing. And so she sued in the state court, Jefferson County. And then that was ultimately removed to federal court. And I'll just say this, for many, many years we've been preaching you file all these cases in state court. And I cover some of these, and I'm going to cover more, but this concept of standing. Do you have the right to even be in federal court? And it is a very, how can I say this, very fluid standard here. And so you might be in great shape and you file the case, and then 6 months later a judge says, well, actually you don't have standing here. So we always file in state court. That way if a federal judge says we don't have standing, we just go back to state court. All right, so standard of review and a motion to dismiss, also known as a 12B6 motion, is it plausible on its face that the facts you've alleged, is it plausible on its face that you can win? And so facial plausibility, where plaintiff pleads factual content, allows the court to draw the reasonable inference defendant's liable. So you must look in the light most favorable to the plaintiff, take all well-pleaded factual allegations as true, but not just something that says the defendant did something wrong. All right, so here's motion to dismiss. And say, like, the FCRA, Fair Credit Reporting Act, exists to ensure fair and accurate credit reporting, promote efficiency, protect privacy. It imposes responsibility upon the furnisher. I'll just say that this motion is only by Truist Bank. So we're not really talking about the credit bureaus here. So responsibility upon furnishers of information to refrain from reporting inaccurate information. So what does that mean? If the completeness or accuracy of information is disputed, the CRAs, the credit bureaus, and the furnisher must conduct reasonable investigation. So the 1681 S2A is the responsibility of the furnisher to only report complete and accurate information, but you can't sue for that. You have to dispute through the FCRA, through the credit bureaus, and then the credit bureaus notify the furnisher, here Truist Bank, and now Truist Bank has the responsibility to do a reasonable investigation under this 1681 S2B. Now, the credit bureaus have to do it under 1681I. Remember, I is for investigation. So if the investigation concludes the information is incomplete or inaccurate or unverifiable, it has to be modified or deleted. And the consumer can sue a furnisher for willful or negligent violation of those duties under Section 1681 S2, and be more specific under S2B, because you can't sue under S2A. So Section 1681N is for willful, and 1681O is for negligence. You would think they would make the the N be negligence, but it's actually reversed. So 1681N is for intentional conduct and O is for negligence. So this is a pretty standard statement. You've got to have an inaccuracy or incompleteness to have a claim. And so Truist, the furnisher, says, well, there's no inaccuracy. Your obligation was not discharged by your husband's bankruptcy, which the plaintiff never argued it was. And they say it was not discharged by Form 1099-C. Well, now that the plaintiff argues against. So she concedes her liability was not discharged through bankruptcy, but insists the reporting was inaccurate because of the IRS form issued by Truist to Rhonda. No dispute that 1099-C was issued, only its legal significance. So the judge is saying here, we don't have to wonder, was it actually issued? Was it not issued? No, it was issued. The question is, does that do anything to the debt? Does that do anything to the credit reporting? So that Truist Bank had an obligation to not report a balance on this debt. So here we go. When discharging a debt of $600 or more, an information return must be completed on a Form 1099-C and filed by the IRS, and there are 9 identifiable events. So subpart A is the event indicating discharge of indebtedness under Title 11, which is bankruptcy. Courts are divided on the effect of issuing a Form 1099-C. Majority hold the filing of the form is irrelevant in discharging a debt. Now, again, we have to be a little careful here because we're using the word discharge in 2 different meanings. So one is a bankruptcy discharge. The other is the issuance of a 1099-C. Can that wipe out or discharge the debt? So providing discharge of indebtedness deemed to have occurred if an identifiable event exists, whether or not actual discharge has occurred, supported by guidance documents. And so this is the majority, that filing that 1099-C, it doesn't mean anything. A minority, however, found the opposite. And then this judge says this is not a novel case. It's 3 times it's been considered in this district, in other words, Western District of Kentucky, based in Louisville. And so they let us know about these other cases. Each time this court declined to dismiss the action, finding it unnecessary to pick either the majority view or the minority view. So the facts alleged do not deviate from this, or do not merit deviation from this precedent. Is not required to prove the merit of her claim, but only to plead a claim that's facially plausible. She's met this standard. So here's a quote. Issuance of a 1099-C standing alone does not prove the debt was discharged. However, to survive a motion to dismiss, plaintiffs do not need to prove anything. I will say this, a lot of judges get confused on this. They go, well, you have to prove that you're going to win. We don't do that at a motion to dismiss. We don't have any sworn testimony from the defendant. We don't have documents from the defendant. There's nothing we can prove. It's not our obligation to prove. It's our obligation to say we have alleged something that's plausible, not just, is it remotely possible in the realm of the universe? No, it's got to be more than that, okay? And so the word that is used is plausible. So as such, there's a dispute at this juncture, the motion to dismiss stage, regarding whether the debt has been discharged, as she claims, or whether she still owes the loan. So here's something from Pennsylvania, noting even though the issuance of 1099-C does not prove it, the debt in fact may have been discharged. So if the plaintiff's interpretation prevails, the debt was discharged and the reporting was inaccurate. If the bank, Truist, interpretation succeeds, the reporting was accurate, and the plaintiff's claims are subverted or lost here. As this court remarked in Baker, discovery may ultimately prove discharge did not in fact occur, but at this stage, the court finds it's plausible. So again, let's just stop for a moment. What the court's saying is, we don't know if the debt was discharged. And it's almost like a chicken or egg thing. The bank will come in and say, your loan was never discharged, never wiped out. Again, we're not talking about bankruptcy discharge. We're talking about under 1099-C. And so it was not discharged, and the mere fact that we issued 1099-C does not make it discharged. And the consumer's argument is, no, you did discharge the debt. You canceled the debt. And then to memorialize that, you sent me a 1099-C. So it's kind of a subtle distinction, but do you see that? The bank is saying, we never discharged it, and then we sent you the form, and the form doesn't mean it's discharged. And the consumer saying, no, you did discharge it, and then you sent me the form. Okay, so the form doesn't make the discharge happen. The discharge had already happened. You had already decided in your mind, Mr. Bank, to cancel this debt. So the consumer's winning this part. But now Truist comes back and says, well, we got this legal versus factual, and I've talked about that a number of times. The argument is that if it's a pure legal question that a judge has to decide, then that may not be appropriate under the Fair Credit Reporting Act to require a furnisher or a credit bureau. Now, you will find this nowhere in the Fair Credit Reporting Act. It's totally created by judges. And I think they may be starting to realize that they sort of created a monster here. And so this judge doesn't get bogged down in it. It just says, look, there are factual issues, okay? Whether the circumstances surrounding the issuance rendered the information inaccurate or incomplete, whether the investigation is reasonable or relevant state of mind. And then, we've got to look at basically the facts of this. We can't decide it now. Now, there are judges that do decide it early on. They should not do that with a furnisher under any circumstances, and really should not do it with a credit bureau, okay? But anyway, this judge just says, look, you're not going to be successful with that at this moment in time. Now, maybe later you will. Now, just to give you sort of the rest of the story, this case was settled, so we have no further orders or information about this case. And then it just talks about willful violations, either intentional or a violation committed in reckless disregard. And so the judge says, look, Truist, you lose your motion, file your answer, your response, and then let's get moving with this case. And ultimately, everybody settled. And the rest of this is just about amending the complaint here. And so motion dismiss is denied. You can see this happened February of this year. So if you're facing a situation where you receive a tax form, a 1099-C, it says, hey, you have income because we have declared this debt uncollectible, canceled, discharged, etc., then this gives part of the roadmap. And some earlier cases cited in here give part of the roadmap for how to be successful with this. So the first step would be to send a dispute to the credit bureaus and make sure you include that 1099 and include something else. Maybe you've got a letter saying you owe the money. Maybe you have a mortgage statement, a car statement, credit card statement, whatever it is. And just show the credit bureaus and the furnisher, Discover Bank, whoever it is, that, hey, this is inconsistent. And I would put in the letter, the debt has been canceled. It has been discharged. And here is the 1099 that reflects that, okay? But, and I know it's sort of subtle, it's not that the 1099 necessarily creates the discharge. It's that it was already discharged. And then the 1099 comes along and memorializes that or documents that, okay? So hope you found this helpful. Let me know if you have any questions or comments, and we'll put out some more of these case videos. I've been kind of collecting some. It's been a little bit of a nutty time for me, but things should be slowing down here in about a week or so, and we'll get more of these cases. And if you run across a case that you would like me to do a review of, just send it to me, and I'll be happy to take a look at it. Okay, guys, have a good one. Bye-bye.